So why is it that this is annoying or distracting to your lawyer? Well, first of all, lawyers have to pay attention to what's being said so that they know when to object, so that they know when to, what is important, what is not important, when to raise their own questions of the witness, to come back to something, etc. By handing post-it notes or notes during questioning, and especially as repeatedly as this person was doing, is terribly distracting. You cannot follow what the witness is saying, and you miss things. So it doesn't help. What I suggest to my clients is that they make notes of important things, or things that they feel are important, or points that are brought up. And we will have time for breaks before we conclude the examination. And at that point, we go and talk about what they've written down and see if it's something that we want to add to the deposition or ask the witness about. Now, a little caveat to that is that my practice is that when I have a good point raised by my client during a break like that, I'm going to not come back and ask that question first. I might ask it first, but then again, I might ask several other questions and then get to that, just so that the other side, the opponents, are not tipped off as to what maybe is a thing that is very important or seems very important, or is a strategy that my client is really thinking about, or something that he's touchy about us or she's concerned about. So that's one thing about depositions. Now, this distraction happens in court as well, and that's even more difficult because you have usually a judge or a magistrate. You have live witnesses, perhaps a jury there, other lawyers, people in the audience. And if you're being interrupted by being handed notes or whispered to or being shoved in the shoulder, you're not going to be able to pay attention as you should to what the questioning is. You're going to miss the chance to do what you have to do as a lawyer, object when necessary, and you're going to miss important points. There's a good chance of that happening. So again, we take our time and have the client write down notes, and then at the appropriate time we can ask for a moment and look over the notes, or there'll be a break and we can look over the notes. I recall, and I'll end with this, just one example of how bad it can get. We had an 11-week trial with a client over a nursing home facility and how it had been improperly insulated. And this led to all sorts of problems where it wasn't being licensed, etc. Now, the client is someone that I've had for a client for years and no longer represent, but I will say this. He would sit beside me and constantly elbow me and whisper in my ear and get upset at what the witness was saying, as if witnesses from the other side were supposed to be just agreeing with him, which is not the way it works. About 8 weeks into the trial, I developed a cold and it kind of settled in my left ear. My client was sitting to that side of me at the counsel table. And people were asking me, why don't you do something about the ear? It seems like your hearing is way down in that ear. And I said, I'm not doing anything because I'm finally getting a break from listening to his distractions and the things that he's saying to me and trying to tell me. You know what? He started to kick at me then. Almost needed to put shin guards on. But it's very distracting and did not help his case at all, even though he thought he was the smartest person in the room, and even got up, left the table when I was trying to pay attention, and slammed the courtroom door. So my advice to everyone out there is don't distract your lawyer, let them do their job. And that's a tip that I think that is very important in this practice of law, and especially during litigation and hearings. Thanks. Have a great day. Visit us again. Remember, we are the Legal Strike Force. We're here for you. And you'll see on the screen our contact information. Hope to hear from you. Thanks and have a great day.